Article 50 European Patent Convention enumerates and spells out subject matter which is patentable under the European Patent Convention. In this provision, which is Article 52, the language that is used is similar, if not identical, to Section 3K of the Patents Act, where computer programs as such are not patentable within the meaning of Article 52. There are two prominent decisions which have gone on to interpret the application of Article 52 in the context of computer programs. Both these decisions, however, take two different approaches to the same issue and come out with two different tests to understand whether or not the subject matter of a patent application attracts the prescription of Article 52(1). The first decision which is of relevance is the YCOM decision. This is the decision of the European Patent Office, wherein it went on to hold that as long as the subject matter is otherwise patentable, merely because it is performed using a modern means such as a computer, it does not render the subject matter ineligible for patent protection. In other words, if there was a lathe machine which was used to perform the function of shaping metal, and if subsequently a computer program is used to run this particular process by way of a CNC machine, then the CNC machine would not be outside the scope of patentability merely because a computer program is used to execute a function which was previously done using conventional means. The problem with this particular test is that it addresses only a certain cross section of situations where a function which was previously performed in the absence of a computer is now being performed using a computer. Therefore, it falls within the definition of computer implemented inventions. It does not take into account those instances or those situations where there is absolutely no conventional means used, and the means used is entirely a computer, and the result or the function that is being performed, or the process that is being performed, or the operation that is being undertaken is executed solely and purely by the computer. What is the law in a situation where there is absolutely no conventional means that is being used? On this particular aspect of the issue, the YCOM decision falls short of a decent explanation. Now, to address this, one could look into the second prominent decision which is of relevance to understand Article 52 of the European Patent Convention, which is the pension benefits partnership system. In this case, the European Patent Office went on to hold that the test of understanding whether or not a certain content in a patent application is patentable is to see if there is any technical character, or if there is any technical contribution, or if there is any technical effect. In other words, if the problem that is sought to be solved by the subject matter claimed in a patent application is technical in nature, and the means that is used to solve the problem is technical in nature, it then rises above the prescription of computer programs as such. Now, the proposition of this particular case could be restated as follows. So long as there is a real world application which is technical in nature, when the word technical is being used, that means it cannot be purely commercial in nature, therefore it cannot attract the prescription of a business method. As long as this happens, then the subject matter of the invention could be deemed as being patentable. This more or less seems to be the sum and substance of the case. Now, the question is this: is there room for exercise of discretion by the European Patent Office within the meaning of Article 52 to look for technical character in a subject matter which otherwise seems to use a computer program to execute its operations? Now, although Article 52 does not spell out this particular requirement of technical character, the spirit of the article and the spirit of the exclusion is very clear. If something is in the realm of pure commerce, such as a business method that is meant to capture the manner in which a business is run, as opposed to a technological solution, then the subject matter clearly attracts the prohibition under Article 52. This could be one way of looking at it. Now, the second legislation that could probably help us understand the concept even clearer would be the UK legislation of 1977, the Copyright Patents Designs Act of 1977. Section 1 of this legislation is similar to Section 3 of the Indian Patents Act, and it again enumerates what is not permissible within the scope of patentability under UK law. As far as Section 1 is concerned, its language comes closer to Section 52 of Article 52 of the European Patent Convention as opposed to Section 3K of the Indian Patents Act. Be that as it may, there is still a subtle difference between Section 1 of the UK Act and Article 52 of the European Patent Convention. The subtle difference is in the language or in the phraseology. However, case laws, or the manner in which Section 1 has been interpreted by the courts of United Kingdom, have more or less ensured that the position between the European Union and the United Kingdom is not significantly different, with very minor variations. The decision that could be looked into to understand the evolution of the law of patentability of computer programs in the United Kingdom would be the Halliburton decision, wherein the Chancery Court, the United Kingdom Chancery Court, went on to identify or prescribe a test to test a patent application on the anvils of Section 1. In doing so, the Chancery Court took into account two other decisions, Aerotel and Symbian, and distilled the following test. Whenever a patent application is being examined, it falls upon the Patent Office to apply the four-step test. The first step is to construe the claims of the specification of the patent specification, to understand what exactly is being claimed by the patent, and this must be done not just on an isolated reading of the claims of the patent, but the written description or the complete specification must be read along with the patent in order to understand what is the sum and substance of the patent claims. Subsequently, the actual contribution of the patent claims or the inventive step that has been claimed in the patent claims must be identified and distilled. Upon identification of the inventive step, the next question that must be asked is whether or not the inventive step falls within the list of prohibited subject matter. If the answer is in the affirmative and the inventive step falls within the list of the prohibited subject matter, the question that must then be asked is whether or not there is a technical contribution as far as the inventive step is concerned, in order for it to be pulled out from the teeth of the prescribed subject matter. In other words, prescribed subject matter plus technical contribution is patentable. Pure prescribed subject matter without technical contribution is not patentable. If one were to refine on this particular idea or on this particular precept, it could be this. If a particular idea elevates itself to the plane of application, to the plane of actual application in a technical fashion, which means if an idea can be reduced to a technological application to solve a specific problem, and since it rises above a mere abstract idea, it lends itself closer to the aspect of patentability as opposed to remaining a pure and simple abstract idea. Now, the best part about the Halliburton decision is that it squarely addresses instances where a computer program is being used in a computer to perform a purely computational function as opposed to a non-computational function. The decision goes on to observe that even if a process is entirely performed using a computer program and is executed on a computer, that by itself cannot exclude it from the scope of patentability. This, I think, is a much more relevant decision, is a much more relevant approach, for the simple reason that this accommodates or permits patentability of computer programs as long as they are applied in the context of telecommunications, as long as they are applied in the context of computation. Let's take, for example, any function that is performed within a cell phone, and this was more or less the case in the Symbian decision of the United Kingdom. In the Symbian case, the classic instance that poses a huge dilemma to the to patent offices on the aspect of patentability of computer programs was tested. If there is a function that is performed in a mobile phone using a computer program, to achieve a result which does not necessarily transform the material or physically transform a particular object, would such a function or would such a process or would such an apparatus deserve the grant of the patent? The answer in this situation was squarely a yes, because it was held that computer programs, when they are used in mobile phones, are not being used in the realm of abstraction, and they are being used in a specific context, and there is a specific technical contribution that comes out during the course of its use or execution in a mobile phone. So, for instance, if a mobile phone has to establish a connection with the telecom tower or the base station, so to speak, then ultimately it is the software or the computer program within it which works on the basis of an algorithm which initiates the action, identifies the appropriate telecom tower with which a connection may be established, and ultimately establishes the connection. It must be understood that although there is a certain amount of hardware involved, at the heart of this process lies the execution of the process by a computer program. In such a situation, if it were to be concluded that this attracts the proscription of computer programs per se under section 3K of the Indian Act or section 1 of the United Kingdom Patents Act or article 52 of the European Patent Convention, then there is absolutely no scope for any innovation or grant of patents in the realm of telecommunication. This would be the consequence of a very restrictive and militantly rigid interpretation of computer programs per se or computer programs as such. Now, one can see that the position from the European Union to the United Kingdom is a position which has broadened itself. In other words, if one were to compare the positions of the European Union and the United Kingdom, the position in the United Kingdom and its interpretation of computer programs as such is broader, pragmatic, and takes into account technological and commercial realities.